Hello and welcome to the Minimum Competence episode for Monday, June 1st, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, Uber flags hallucinated case law in MDL, Seventh Circuit nixes email service to China, the Roundup MDL fight, plus Trump's IRS deal under review. Let's remember, you can pickle anything if you care enough, and read today's legal news. On this day in legal history, June 1st, 1789, President George Washington signed the first statute ever enacted by Congress under the new Constitution, an act to regulate the time and manner of administering certain oaths, codified at 1 Stat 23. The substance was modest. The law prescribed the form of the oath that members of Congress, federal judges, and executive officers were to take to support the Constitution, and gave the states a window in which to swear in their own officials. But the symbolism was enormous. It was the first time the new federal government did the thing governments actually do, which is to pass a law and require people to obey it. And the choice of subject was telling. Before Congress regulated commerce, levied taxes, or built courts, it bound its own officers to the Constitution by oath. The oath clauses in Article 2 and Article 6 have been doing quiet doctrinal work ever since. They ground the Supremacy Clause. They undergird Marbury's claim that judges are bound to follow the Constitution as supreme law, and they sit at the center of the 14th Amendment, Section 3 disqualification debate that the Supreme Court took up in Trump v. Anderson just 2 years ago. The Oath Act of 1789 is not the kind of statute that gets quoted on bar exams, but it is the original instance of Congress speaking in legal form, and everything the federal government has done since rests on top of it. Uber went after one of its own bellwether plaintiffs Friday in the sprawling multi-district litigation over alleged passenger sexual assaults, asking U.S. Magistrate Judge Lisa J. Cisneros in the Northern District of California to impose sanctions on plaintiff BL and her counsel at Wagstaff Law Firm for what Uber called pervasive bad faith in discovery. The headline accusation made by Kirkland & Ellis's Michael Vives for Uber is that BL's privilege log cites cases that do not exist. What Vives suggested may be hallucinated case law generated by an AI tool, and Vives floated that as an independent basis for sanctions on top of the alleged document withholding, redactions, and undisclosed witnesses Uber cataloged in its April motion. The legal vehicle here is Federal Rule of Civil Procedure 37, which gives a federal court a tiered menu of sanctions for discovery misconduct, fees and costs at the low end, adverse inference instructions, and claim preclusion at the high end, and Uber is asking the court to throw BL's case out of the next bellwether wave entirely. Judge Cisneros noticed during the hearing that what struck her about the briefing was the pattern, not any single one incident. She pointed to one example where the plaintiff identified a person as a friend and only later produced a fuller set of text messages showing the person was actually a therapist. The judge ordered the plaintiff to file a surreply by Thursday before ruling, which means a sanctions order is now teed up. The case sits within In Re Uber Technologies, Inc. passenger sexual assault litigation, MDL number 3084, before Judge Charles R. Breyer, and any sanctions ruling will set the tone for how the rest of the bellwether pool conducts discovery. If the hallucinated case law piece sticks, this also becomes one of the first real Rule 11, Rule 37 hybrid sanction vehicles for generative AI misuse in the MDL context, and the bar will be reading it closely. The Seventh Circuit on Friday told the Northern District of Illinois that the now standard practice of serving Chinese e-commerce defendants by email in Schedule A trademark cases doesn't fly under the Hague Service Convention, at least not when the convention applies, which is a question the district court has to actually answer first. The dispute came up in Kangal LLC v. Hangzhou Chunwai Silk Import and Export Co., where the hatmaker Kangal sued more than 20 Chinese vendors for trademark infringement and identified them on a sealed Schedule A exhibit attached to the complaint. The same procedural pattern that drives the enormous Schedule A docket in Chicago's federal court. Kangal got a default judgment after serving the defendants by email, but one defendant appeared and moved to vacate, arguing that the Hague Convention prohibits email service in China and that the convention applies because Hangzhou's address is discoverable. The legal hook is Article 10A of the Hague Service Convention, which permits service by, quote, postal channels only when the destination state has not objected, and China has affirmatively objected to Article 10A full stop. The Seventh Circuit, citing the Supreme Court's 2017 decision in Watersplash Inc. v. Meenan, held that whether or not email counts as a postal channel, Article 10A is unavailable in China, so email service in this case was improper if the convention applied at all. The panel, Judges Thomas Kirsch, Candace Jackson Akawumi, and Doris Pryor, reversed the denial of Hangzhou's motion to vacate and sent the case back for the threshold question the district court skipped. Did Kangal make reasonably diligent efforts to find Hangzhou's address, which would have triggered the convention? The practical fallout will reach hundreds, possibly thousands of pending Schedule A cases in Chicago that rely on email service as a matter of course, and plaintiff firms in the space will be scrambling to redo their service strategy. The Judicial Panel on Multi-District Litigation on Thursday transferred Randall King's proposed class action, the vehicle for a proposed $7.25 billion Roundup settlement with Monsanto, into the Northern District of California MDL before Judge Vince Chabria, despite vehement objections from absent class members who want the case to stay in Missouri State Court. The case within a case is unusual. The King action was filed and preliminarily settled in Missouri State Court. Then a group of objectors, represented by Keller Postman, removed it to federal court under the Class Action Fairness Act, and the JPML then tagged it to transfer for the consolidated Roundup MDL. The legal hook here is 28 U.S.C. 1407, the JPML's transfer authority, paired with CAFA's removal rules, which the settling plaintiffs argue were misused, because the objectors aren't defendants within the meaning of Section 1453 and so cannot remove to federal court. The objectors counter that the $7.25 billion deal launders a liability management scheme through the courts by funneling claims of Roundup cancer victims through a Missouri state court class that an MDL judge would never approve. And they want federal court scrutiny under Rule 23 and the standards Judge Chabria has spent years developing in the Roundup litigation. Monsanto, for its part, is on the objector's side of the venue question, at least tactically, telling Law 360 in an interview that the case should go back to Missouri State Court and it will move to oppose the transfer order. The whole fight is also tied up with the Supreme Court's pending decision in a separate Monsanto case that will determine whether the deal survives at all, because the proposed $7.25 billion is structured around what the court does there. Whichever way this remand transfer fight comes out is going to be cited in every future class settlement jurisdiction tug of war for the rest of the decade. A U.S. district judge in Florida said Saturday she will take a closer look at the settlement the Trump administration has reached with itself, or more precisely with President Trump in his personal capacity, over a long-running IRS lawsuit, scheduling further proceedings to examine whether the deal can stand. The procedural posture is what makes this one interesting. The case involves a federal agency under the president's control, settling claims with the president personally, which raises immediate questions about whether anyone is actually adverse to anyone, and whether the resulting consent decree or stipulation can carry the legal weight a normal settlement does. The legal mechanism the judge appears to be invoking is the federal court's inherent supervisory authority over consent decrees and settlements involving the federal government, an authority that runs through cases like Local Number 93 v. City of Cleveland, and that the Tunney Act formalizes for antitrust settlements. Though here, there is no Tunney Act, just the general principle that a federal court doesn't have to rubber stamp a settlement when there are serious questions about whether the United States was actually represented in the negotiation. The hearing on the issue was set for late May in Miami, with the judge reportedly skeptical that the deal could be approved without further factual development. The political stakes are obvious, but the legal stakes are arguably bigger. If the court can refuse to approve the settlement on the ground that the executive branch was not adverse to itself in any meaningful way, it would create a precedent that constrains every future administration's ability to make its own personal litigation go away through agency action. Expect this one to generate appellate motion practice within weeks. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes, an email, newsletter, form. We'll see you back here tomorrow. And until then, remember, shoot for the moon. If you miss, you'll probably land in a tree and scare some birds.